Good morning, everybody. Welcome to the First District Court of Appeals. We have two cases to be argued this morning. I'm going to call both cases. If counsel could introduce yourselves and indicate your readiness to proceed. First case is State versus You.
Josh Thompson on behalf of the city, ready to proceed, Your Honor.
Okay.
Chris Bowers on behalf of the city of Cincinnati, ready to proceed, Your
All
Honor.
right. Thank you. And the second case is State versus Fisher.
Laura Peters on behalf of Marquette Fisher, ready to proceed.
Keith Sauter for the state, Your Honor, ready to proceed.
Okay. So for State versus You, counsel can please approach. Mr. Thompson, how much rebuttal time would you like?
5 minutes, Your Honor.
Very well. And you may proceed when you're ready.
May it please the court, counsel. The trial court in this case denied misuse applications for sealing and expungement without an on-the-record hearing. Under 2953.32, the court must weigh the applicant's interests in sealing the applicant's records against the legitimate needs, if any, of the government. After weighing those interests of the applicant and the government, the court shall order all records of the case sealed if the legitimate government needs to maintain those records do not outweigh the applicant's interest in stealing her records. Now here, from the record, we know that Ms. Yu was at the very least interested enough in having her records sealed and expunged to have filed the necessary applications. We also know that the record shows no legitimate need of the government in retaining these records. The state did not file a written objection. It is also worth noting that the state argued in its brief that Ms. Yu's counsel did not demand a formal hearing, but Ms. Yu did not have counsel for the sealing and expungement applications.
So what happened below? Like, a hearing was scheduled.
Correct.
Do we
And
know that it occurred, or do we not?
We know from the entries that the applications were denied, that the entry went on. So at the very least, we know the case was called and an entry was put on.
Let me ask you, how would you have a hearing if the proponent of the expungement doesn't appear? What would you do? How would you do it?
I believe that the case would be called, and then at the very least, if the state had any interests in having these records maintained, they could put those on the record.
Counsel, do we even know that that's what happened here, though? Because we have no record from the court date.
We don't. We have to make some assumptions along the way. But
Is one of those assumptions regularity?
yes.
Are we permitted to assume regularity, or does case law require some explanation by the trial court of why it denied these
So-
applications?
When I say regularity, what I heard in my head was, from experience in municipal court, is the case got called, and then Ms. Yu either was or wasn't there, and an entry was put on. So that's what I hear. But yes, the court does need to still consider these factors. And given that it made an entry, I think if we're assuming regularity, we are also assuming that those factors were considered and no findings were made besides denial.
We have two differently postured sets of cases here, right? We have one case or one application with a completely silent denial, just denied with no further explanation. And that's for an application to seal a record of non-conviction. And then we have another set of entries. One of the charges is a non-conviction, one's a conviction, and we have some language in the denial that Ms. Yu was facing the same charges in another jurisdiction. Is that enough? Do we treat these the same or different? How do we look at the fact that one entry is completely silent as to its reasoning and the other set of entries has some explanation?
So the silent entry is the most obvious case to me that should have been granted, and it was an abuse not to, because not only was it a non-conviction, but it was a dismissal at the request of the prosecuting attorney. So that one, there's no rehabilitation to consider, nothing like that. That, to me, is the obvious one. The other case.
Obvious in what way? I mean, the trial court explained nothing, so
So
what is
it's
obvious about it?
It is obvious that without any explanation, that it was an abuse of discretion to deny that application. There is no interest expressed from the state whatsoever.
And what interest is expressed from Ms. Yu on this record?
Her application,
And what does the application say?
to have her record sealed and expunged. I think my position is that filing is at the bare minimum showing an interest that you want your record expunged.
All right, so your position on the 6123, the licensing case, is that all she needs to do is file an application, and if the state sits silent and the court sits silent, that that's an abuse of discretion.
It is.
All right. And then turning to the other two, we have some explanation from the trial court, which is that she was facing the same charges in another jurisdiction. Does that change the equation?
Ultimately, no. The probation report that I believe was supplemented says that the charges were not pending. We know that these charges existed. We don't know what happened. We don't have a finding from the trial court in its entry that Ms. Yu was not eligible. It's simply a notation that these charges existed.
Why couldn't the trial court presume that that meant that the charges were still pending because there was no information in the probation report as to their disposition?
On the front page of the probation report that I have, there is an X marking, there are no pending charges in regards to this applicant. That's what I'm relying on.
But I guess getting back to part of Judge Kinsley's question, like, your position is there's no real affirmative burden on the applicant other than to just file something and say, I want expungement. They don't really have to develop the record to show the various criteria as long as the state's not opposing it.
Essentially, yes. The statute requires that the applicant's interests be no worse than equal to the state's interest. And if an application is filed, an interest is shown, and if the state raises no objection whatsoever, one can safely assume they have no interest in maintaining these records.
The criteria is different with regards to a non-conviction and a conviction. And there is a little bit more burden placed on an applicant in a conviction posture, in that rehabilitation needs to be shown. Our court has said that a period of living a law-abiding life can show rehabilitation. Do we have that in this case? How would the trial court weigh that? If that were the case, did the trial court weigh that? What do we know about how the trial court reached its decision in the conviction case?
We know nothing about how the court reached its decision. What we do know is that the record in Hamilton County is the last thing that we know about were these 2018 cases. And we know something happened in Missouri, but we have no finding of a lack of rehabilitation. So my posture is that we assume without that finding that the finding was made, that there was rehabilitation.
Well, what do we do with this same charges language? I mean, what criteria does that relate to?
I think that if anything, it shows an abuse of discretion in considering charges that show nothing. It shows that a court, if anything, considered a lack of conviction, a lack of dismissal, a lack of anything.
Well, isn't the trial court permitted to consider any other factor that relates to rehabilitation? And why would an arrest not be part of that calculus?
Yes, that language exists. An arrest is simply an indication that someone got arrested. It shows nothing toward rehabilitation, is the position of Ms. Yu here.
Do we know if the trial court considered the same charges as part of rehabilitation, or was this an eligibility determination?
We don't know. If there are no further questions, I will ask the court to find that the trial court abused its discretion in denying misuse applications and reserve the remainder of my time.
Thank you, Mr. Thompson. Mr. Powers?
Morning.
Morning.
State believes the linchpin of this issue is that Ms. Yu did not attempt to show up and prosecute her own application.
Well, she's not required to, correct? I mean, the statute puts the burden on the trial court to conduct a hearing.
Absolutely. But she wasn't there.
How do we know that?
I think it was reflected in the, that was reflected in appellant's brief that she wasn't present due to the distance, her residency in Chicago.
What was this? Was anyone from the state there?
On that matter, I would have to assume that a room prosecutor was present. The essential point here is that there are so many things we do not know because there was not a hearing. I think every question being posed, that has been posed so far today would be answered with a hearing held at that state at the trial court level. Without that, we are left to assume an incredible number of things.
So
And
this case would benefit from a hearing?
I think that ultimately, I think the least restrictive means here, Ms. Yu is not barred from reapplying for this. That, and there is some note from the judge about a charge that we don't know the full details of. We don't know if it was resolved. If it wasn't resolved, it would be dispositive. If it was an active case, she wouldn't be eligible for any of these charges to be expunged, excuse me.
So I've asked this question at several different arguments about expungement where the state doesn't file anything below, doesn't raise any objection. So you all did not feel strongly enough about this to oppose it below. Like, why are you resisting it now? Like, what's the state's interest?
I believe the state's interest here is the reflection that the judge noted, based on the limited information that we have, is that there was a similar charge pending in this, which I think is clearly indicative of a lack of rehabilitation.
What, was it pending? Because the probation report indicates that there are no charges pending in other jurisdictions.
That much, I guess, and again, we have to guess. These are all questions that I just feel that a hearing would be the perfect instrument to flesh out. And we have to guess as to why Ms. Yu wasn't there, or if she was there.
Well, did the trial court err by not having a hearing?
It would be my position that they did not. Given the judgment entry on that, based on statements made by appellant in their brief, he wasn't there. That, again, we have to kind of assume that because we do not have a transcript, we do not have a fleshed out record
Well,
here.
could her attorney waive her presence? I mean, in theory, a hearing could go forward without her personally being there, right?
And that was based on the way things were posed in appellant's brief. I was under the understanding that Ms. Colliver represented her at the trial court setting. Counsel said that she did not have counsel representing her at that level at all. I mean, if she did have an attorney there, we don't know if she requested to waive her presence. Every question that we turn to comes to either a we don't know or we have to kind of take an educated guess. And I can't help but feel that just by not being there, by not, expressing her own interest in prosecuting this above the simple application itself.
Well, we really don't know, right? I mean, it's equally possible that she was there and the trial court had predetermined that it was going to deny these applications, and so it denied them without a hearing. That's also possible. We just don't know.
It is possible, and I think, again, that just falls back to the underlying crux of every issue on this is that a hearing would answer every question that all
Well, getting back
parties-
to my question,
Sorry.
statutorily, there should be a hearing. And so was it error not to convene a hearing by the trial court? Like, even if she doesn't show up, then you say, well, at least enter on the judgment entry, like, hearing scheduled, applicant didn't show up, I'm denying it, something like that.
That's a fair question. I don't know if I have an answer for that. At that point, falling into more of my own personal opinions on matter. I'm not aware of any
Okay.
case law that demands that, but I do understand your point.
If there is case law requiring the trial court to conduct a hearing, what should we do?
I personally believe that, playing along with that, and then in that if scenario, that if a hearing was required, then I think that the second least most restrictive means here would be to just remand this case back and have the trial court hold a hearing. I personally feel that the least restrictive means is to just, uphold the trial court's discretion. It feels like they noted some discretion in this about the parallel charge, that they were concerned in it, and the charges were in Missouri in 2022, the underlying charges were from 2018, less than 4 years in a completely different jurisdiction. That seems indicative of a lack of rehabilitation to me, and Ms. Yu is still within her rights to reapply. That being said, if you weren't inclined to find that to be the most least restrictive means, I think the next most appropriate step would be to send this back to the trial court with instructions to have a hearing to properly flesh out all of these excellent questions that we do not have answers to.
Is there a difference between the sets of cases? So there's the silent record one with no explanation, just a denial, and then the two that say that have the same charges language. Are these the same or different in terms of our course of action?
I think they would need to be treated the same without a record to show what differentiates the two. I think that would be, I see potential pitfalls, in that, in sending it back or upholding overturning that denial, granting the expungement here. I think it would be more appropriate to send it back to the trial court and have them have a hearing. Ultimately, they are the people in the best position to exercise their discretion. We just have no real insight into what that discretion was, aside from a note that we need a Mandarin interpreter and a note about a pending charge.
And does the city have a position about the same charges language in what it relates to? Because I see a number of ways we could interpret that. So it could go to eligibility. It could make Miss Yu ineligible in the trial court's perspective because there was another charge pending. It could go to rehabilitation. It could go to the state's interest. It could go to all three. Do you have a position as to what that language means in terms of the statutory criteria?
I don't have a position without trying to get into the head of one of the municipal court Judge Bouchard. I'm not Judge Bouchard. I'm not sure what he was thinking, what his exact thought process was, and we have such little information to try to discern that, that I cannot confidently take a position about the specifics of what he meant. Again, we assume, my assumption from the reading of it, and again, this is just my personal read on it, is that a conviction of solicitation was the underlying charge, I believe, prostitution. And the conviction of that, and then a note of a similar charge in another offense, I would read that to think it is a similar solicitation charge. But again, I don't know. I can't say that with 1,000% certainty. I won't. The hearing answers all these questions. If there are no more of the questions, I would submit on the remainder of my written brief.
Thank you very much.
Thank you.
Mr. Thompson?
The one thing we can safely assume in this situation is that the interested party, the quote-unquote victim here, the state, was present and didn't object. And if we are weighing interests of either equal or greater on one side, then they are at no worse than equal that Ms. Yu's interest in having her record expunged. So therefore, our position is it is an abuse of discretion to deny her application. If the court is inclined to find that a hearing should take place, the better course of action, I believe, would be to remand for a hearing, not to affirm the denial.
Did you all make that argument in your brief?
No, but the state's argument was that the denial essentially should be affirmed, and today said remand. So if we went that route, if the court goes that route, I would say remand would be the better path. If there are no further questions, I'll just ask the court to expunge and seal this use records.
Thank you. Thank you both for your arguments. The case will be submitted. We'll get out a timely written decision. We both have a great day. Morning, Ms. Peters. How are you?
Good morning.
How much time would you like for rebuttal?
I'd like to reserve 3 minutes,
3
please.
minutes. Very well.
May it please the court, my name is Laura Peters, and I represent Marquel Fisher in this matter. There's a saying that the devil is in the details, and it's the details in this case which show that Mr. Fisher's Fourth Amendment rights were violated because there was not reasonable articulable suspicion that he was engaged in criminal activity that night. This incident, the stop of my client was precipitated by an armed robbery at Frisch's near the borderline between Hamilton County and Warren County. In aid of, Hamilton County called for aid in setting up a perimeter, and Warren County officers responded. Deputy Price from Hamilton County Sheriff's Department went to the Frisch's and was able to review the video surveillance of the crime being committed. And he provided an updated description to all responding officers.
But was that after the stop?
No, the updated description was before Mr. Fisher was ever stopped.
Okay.
Counsel, what do we do with the fact that, I think it's Officer Bill Meyer, I might be pronouncing his name incorrectly, that in his testimony at the motion to suppress, he didn't recall all of the details from the updated dispatch. And critically, he didn't recall the ones that didn't match. How does that factor into the equation?
Well, Deputy Bill Meyer, and I'm going to go with you on that pronunciation because I don't know any better. His knowledge, he doesn't have firsthand knowledge. And so basically what he's relying on is what we call the collective knowledge doctrine. So what is critical here is actually what is the knowledge that Deputy Price had, since he is the one who provided the dispatch. So the test, now, part of the test is whether the responding officer acted objectively within the facts known to him, meaning the description that was provided. But there are two other aspects of consideration that the trial court failed to actually really engage in.
So can I just stop you right there? So it's your position that we look at what the dispatch actually said and not what Deputy Bill Meyer recalled that it said?
Correct, and that comes from, the Ohio Supreme Court, I believe a case I cited was Mommy versus Wisner, in which and there are several other cases say the same thing, and that you have to look at what precipitated the dispatch. So what is the information that precipitated the dispatch? What was known to the dispatching officer? Because the responding officer doesn't have firsthand knowledge. They have to rely solely on what's in the dispatch.
Right, and so like if the dispatching officer doesn't itemize every single detail or makes a mistake or doesn't recall something accurately, like what do we do with that?
Well,
I mean, because aren't we looking at like what the officer who hears the dispatch, like they have this universe of facts and they may be complete, they may be incomplete, they could be correct, they could be wrong, but they take those universe of facts and they see someone like, I think that's the guy. Like, I'm trying to understand how you all are like envisioning the collective knowledge doctrine
yeah.
or whatever.
Well, the value of the collective knowledge doctrine is that the information that is shared between law enforcement officers, so that not each individual officer needs to have firsthand knowledge, is that the information shared is accurate and complete. So if the information that a responding officer acts on is not accurate and complete, there is a Fourth Amendment violation. Because, like in this case, the major description of Mr. Fisher, or the perpetrator was that he was biracial or a mixed race, that he had lighter skin. And that description undeniably did not match Mr. Fisher. Deputy Price admitted it at the suppression hearing, and so did Deputy Bill Meyer.
So your position is that Deputy Price was required to include that detail in the dispatch and did not, and therefore we should impute that detail to Deputy Bill Meyer, whether he knew it or not.
Correct. And in the 10th District case, State versus Johnson, they kind of boil it down to, would Deputy Price have been able to stop Mr. Fisher like Deputy Bill Meyer did, based on his knowledge and facts, because he was the dispatching officer? And the answer to that is clearly no, because not only does he not meet the ethnicity of the perpetrator, but there was also clothing descriptions that Deputy Price knew that didn't match what my client was wearing.
And part of the issue I guess I'm struggling with in that regard is that when Deputy Bill Meyer testified, he didn't seem to recall that. So he recalled a black male wearing a dark hoodie, and that's it. And he didn't recall the zip-up part, and he didn't recall the Nike logo. And so then when he confronted a person who matched this generic description, but not the extra detail, he felt that he had, met the right person because he forgot the extra detail that didn't match the person he was looking at. And so what do we do with the gap in his memory and the gap in his ability to digest the specifics of the dispatch?
The gap in his memory is problematic in that because he doesn't remember the description at the time of the suppression hearing. He does later on in his testimony talk about that he knew it was supposed to be a Nike sweatshirt. He maybe didn't recall that it was supposed to be a zip-up. But he did recall that it was supposed to be Nike, and then when confronted by defense counsel, well, the sweatshirt Mr. Fisher was wearing had a big white emblem, and he then tried to become evasive and said, well, I don't know if that was a Nike sweatshirt or not, but it ignored the part of the dispatch that it was the Nike logo was on the left chest area, and then left out was that it was red. So the state shouldn't benefit because Deputy Bill Meyer has a faulty memory. At the suppression hearing, you should look at what was the dispatch given, and that was clearly testified to on transcript page 36, that this is the updated description. This is the person that they were looking for. And even if you don't agree that you look at what Deputy Price knew, even the dispatch that was testified to, my client didn't satisfy that dispatch. So
Was it close enough to be reasonable?
No, Your Honor.
Why?
Because my client was significantly, the dispatch, if you go through it, was black male, okay, 6 foot tall. My client was well above 6 foot tall. Average build. My client was a large black man. Zip-up hoodie, pullover hoodie, Nike emblem on the left chest, big white emblem all over and then possibly gray boots. Well, he doesn't actually describe the color boots that my client was wearing. He just said, oh, he was wearing boots and he had dark colored clothing. And he had something on his head, but again, the initial dispatch was dark clothing. Well, the bandana that my client was wearing was white. So there are a lot of differences. Plus, there's also the difference that my client was just walking with a female, because there was no indication that there was anybody else involved in the robbery. And my client was just seen walking with a female. And that's what attracted Deputy Bill Meyer's attention. So no, I don't think it was reasonable at the time to stop my client, even based on the limited description that they had. And then when you add in what Deputy Price knew, it definitely falls short of the Fourth Amendment, because he was not a light-skinned black male, and the logo on the sweatshirt was red.
Was the white emblem on his sweatshirt a Nike emblem?
No.
Okay.
And that was very evident.
Okay.
I believe there was, one of the exhibits was a still shot of my client, and it shows it's a white, it's big and white.
Okay.
And it takes up most of the front versus the Nike red swoosh that was just on the left chest.
Okay.
Let me ask this, Ms. Peters, are we permitted to consider your client's behavior after the officer stopped him or said, come over here, take your hands out of your pockets, sit on this bumper, and then the struggle that ensued when he tried to pat him down? Is that something we ought to consider?
If the facts detail give additional indication of reasonable suspicion that he's committing a criminal activity, but our position is that he had no business even stopping him. So we're taking it at the initial stop. So that anything else after that is irrelevant to our inquiries, because the initial stop was bad. So if the court has no other questions, we would ask that you reverse and grant a suppression of the evidence.
Okay, thank you very much. Mr. Souter?
Good morning, Your Honors. May it please the court, counsel. I think the thing that we have to keep in mind in these cases, first of all, is that the touchstone of all these Fourth Amendment cases is reasonability. And I think we have to put ourselves in the context of what Deputy Bill Meyer was doing that night. It was in the aftermath of an armed robbery, so it's a emotionally charged situation. It's in the middle of the night. He's tasked with trying to find somebody who might be walking around with a gun. And I think that the information that he had was corroborated by what he saw. And the updated dispatch, to the extent that it was updated, wasn't fundamentally different from
Well,
the
go back
initial
to like
dispatch.
what Ms. Peters said a moment ago about like the discrepancy in height and build, type of sweatshirt, the attire. Like, to me, like, one of those factors, whatever, but the more factors that there are distinctions with, the more it's not looking reasonable.
Yeah, and I think that's the calculus, right? I mean, I think the closer the better, obviously, and you don't want
Right.
to pick up people who are clearly not, don't match the description of the perpetrator, but I don't think we have that in this case. It was, again, it was at night. He was approaching this person with, with caution. Maybe didn't even, didn't take the time or didn't have the time to look at what kind of a logo was on his sweatshirt. But clearly it met the description that he had was pretty close to what, to Mr. Fisher's physical characteristics, his clothing, and his behavior.
Do we know how tall he is?
In the transcript, it says he's between 6 feet and 6 feet 4. So it's not wildly divergent from what was in the dispatch. And, it's a description that's taken from a still of a surveillance camera, and there are just different gradations of what kind of information you can get from that. And I think that, given that the touchstone of these is always reasonability, and the fact that the only thing that that Officer Billmeyer had to have was some sort of articulable suspicion, this doesn't even have to rise to the level of probable cause. And I think that when he sees this person who matches the general description of the dispatch, person has dirt on his clothing as if he's been, I don't know, crouching or lying down or attempting to hide. I think that's another thing that adds a lot to the determination here. And I just think that if Detective Billmeyer were in my neighborhood, I would want him to investigate this. I'll put it that way. And I don't think he did.
What is the state's position on how the collective knowledge doctrine should or shouldn't be applied? Because I think we've had some cases where you all have been the proponents of the collective knowledge.
Yeah, it usually works the other
It
way.
cuts both ways.
It absolutely does. As I said before, I think that if the updated version of the description would have been fundamentally different from the initial description, I think that you would have to impute that knowledge to Detective Billmeyer. But I don't think that's the case here. I think that there were some differences in the nuances of the description, but not something that would absolutely foreclose Tavon Fisher from being the.
But what about the fact that Deputy Price immediately said, "This is not the guy"?
Well, he knew the person. He knew Tavon is the thing. So when you're standing face to face with somebody you know, it's completely different from looking at a picture of a surveillance camera. If somebody you know from the neighborhood walks in and he says, "Oh wait, no, that's Twin. I know the guy. I can tell from the surveillance video that this isn't a person I know." If it had been a person they had brought back for the show up who he had never met before, and he was able to say, "Yeah, that's not the person," I think we'd have a different case here. But I think his familiarity with Twin or with Tavon Fisher kind of militates in favor of the position the trial court took.
And what about this logo difference and the lack of a zip-up hoodie? Can you address that? I've watched the video. I mean, the white, looks like cross paint stuff that's on the on the sweatshirt. It's clearly not a Nike logo. It's not on the left corner, and it's not a zip-up hoodie. Do those differences matter here?
Well, I mean, once again, it's a matter of reasonability. I mean, if you would make the conclusion that would absolutely foreclose any possibility that the person he approached was not the robber, then I guess you would come to the conclusion that the motion to suppress should have been granted. But as Deputy Billmeyer and Officer Price stated at the suppression hearing, it's kind of a holistic or gestalt kind of a thing when you're looking for somebody in the heat of the moment. And the distinctions about what kind of logo, I wouldn't, I probably wouldn't know a Nike logo from an Adidas logo. It's not my thing. So I think it's just one of the many factors that went into him having the reasonable suspicion that this person was the person he was looking for. And I don't think we would want to dissuade him from making this investigation.
And did Deputy Billmeyer know the source of the dispatch information? So did he know that Deputy Price had viewed the surveillance video and that's where it was coming from? Or did he just know that this was updated general information about the suspect?
From my reading of the motion to suppress transcript, it doesn't appear that he knew it was from a surveillance video, but it might indicate that in the record. That would be apparent from that. But my reading of it is that he just knew that this was a dispatch. Here's the information we have. Not that there was anything captured from a surveillance video, but I could be incorrect about that.
Would that matter if he knew? I mean, surveillance video evidence, I would think, would be deemed pretty reliable by an officer as opposed to maybe like an eyewitness tip or anonymous tip or something. So would that matter to him, or would it matter to us if he knew that?
Well, I mean, it's just another thing to consider in determining the reasonability of this investigation. I'm not sure which way that cuts. I'd have to think about it, but there are so many factors that go into these things that to sit back and second guess what this officer did on that night, is a bit unfair in light of the information that he did have, the correct information that he did have, and the information that was corroborated when he came upon Mr. Fisher on the night of the arrest. And I would just say that there's nothing we can say that the officer did here that was unreasonable within the meaning of the Fourth Amendment. And if there are no further questions, I would just ask the court to affirm.
Great, thank you.
Thank you.
Ms. Peters?
I wanted to touch on a couple of things that Mr. Sauer raised. First, the details matter. Deputy Billmeyer even testified at the suppression hearing, the more details we have, the better for us. What details were missing? That this was a biracial, mixed race or lighter-skinned black male, and that there was a red Nike logo. These would have been significant details that would have.
Well, I just want to understand your position, like, a zip-up sweatshirt can easily be removed, right? So you wouldn't say that, like, we are not allowed to stop anyone unless they are wearing a specific Nike logo sweatshirt, right?
Correct.
Okay.
Obviously, the one thing that's not going to change is the color of somebody's skin.
Sure, sure.
And that is a significant detail in light of this. And I know Mr. Sauer talked about how Deputy Price knew my client. But he said, he testified, as soon as I saw him, I said, that's not the guy we are looking for. We don't call him Marquel, we call him Twin. He's one of two. We are very familiar with him. The guy that appeared in the video from Frisch's appeared to be like a biracial gentleman, which is clearly not Twin. So when he sees the person, I don't think he's going to necessarily recognize immediately that it's Twin, but what will he immediately recognize is that this is a darker-skinned black male versus a lighter-skinned black male who is the perpetrator of the offense. And even Deputy Price, when looking at whether or not Deputy Billmeyer actually acted on the limited description that he had, said on page, I think it was page 25, well, he's kind of met the description, and then later on testified on page 27 through 28, I believe, was that the clothing wasn't an exact match. And I agree, yes, the clothing can change, but when that's the description, and there's significant number of discrepancies with what the clothing is, and I do take issue with, because I don't believe that the record showed that my client was crouching, he was walking on a sidewalk. He wasn't hiding, he just had escorted a female home. So in light of all those scenarios and the factual that this court knows and what Deputy Price knew, there was not reasonable suspicion to stop Mr. Fisher. Thank you.
Thank you. Thank you both for your arguments this morning. The case will be submitted. We'll get out a timely written decision, and I hope you both have a great day.